I erased them before I even knew I was getting subpoenaed. It was,
I'm not saying that you did anything wrong. That's not what I'm saying.
Okay.
What I'm saying is you wouldn't necessarily, the way the two of you were carrying on, feel comfortable having anybody in this courtroom read all of those text messages based on, some of them were dirty, right?
yeah, probably, yeah.
And in your TikToks and Snapchats back and forth, and Instagram messages, did y'all do Instagram messages?
I think there was one video shared.
You, one of the TikToks you shared with her said something about show me your titties. Do you remember that?
Not necessarily.
Okay. I mean, you're not proud of what you two sent back and forth, are you?
But in a private conversation, I mean, that's a private conversation. You don't really expect it to be aired out in court, but.
Fair enough, and I'm not gonna air it very much.
Okay.
But you understand that you're married and she's married, and probably in retrospect, the two of you shouldn't have been sending those messages back and forth.
Yes.
Fair enough?
Yeah, there's, she said she was getting divorced. I'm also getting divorced. So,
So in May of this
was,
year, she said she was getting a divorce?
yes,
Okay. To your knowledge, did she ever file for divorce?
no,
And she met you, instead of going home several times, she went to the post office to meet you. She met you at work twice. She bought you a shirt, is that correct?
yes,
And you took her lunch to her work several times, and then you saw her at one of your dental appointments, is that correct?
yes.
This is what you sent her. Judge, if I may approach.
All right.
I love
Yeah, it's like a meme.
two married parties, that's probably not appropriate, is it?
No,
After you got subpoenaed and she found out that you were subpoenaed, did she contact you?
yes, she called me.
Okay. And,
I didn't answer. I was in a meeting at work.
okay, and what did the two of you say to one another?
I don't know. It's there. I don't know exactly what was said. She called me. I said, I'm in a meeting. She said, Ethan is, taking you to court or subpoenaing you or whatever. And I said, yeah, I know. I just got served like 20 minutes ago. I don't know what else was said after that. It's there though.
Okay, was she telling you what you had and had not done with her in some of those text messages about, pretty sure we'd only had one lunch, you brought me lunch once?
That's what it seemed like. So I just said this conversation is over because I knew I would have to supply what I did have, and I didn't want it to seem like.
The courtroom
were-
shifts from proving facts to measuring credibility. That distinction matters because custody cases rarely turn on one mistake. They turn on whether the judge believes someone is being completely honest. The questioning exposes more than deleted messages or private conversations.
We were concocting some kind of plan or
Right,
something.
and you've said today that you brought her lunch more than once and she brought you lunch more than once. Is that correct,
Absolutely,
sir?
yeah.
Ms. Duke, this is not a divorce hearing. This is only on the custody issues. Is there a reason why we have to hear all of this about what's going on? I mean, obviously, this is an extramarital relationship between him and her, and that has been well established. But beyond that, is there any relevance to the?
Time away from the children, time away from the child.
I think you've established that. so.
And I am done actually with him, but I would like to submit this as the next market.
Hand that to the clerk if you. And again, Ms. Williams, you have the opportunity to ask questions if you want. All right, thank you, sir. You may step down.
Thank you.
Plaintiff has rested their proof. Ms. Williams, do you wish to testify? I'm not, understand, you are not required to testify. You're acting as your own attorney. Today's hearing is a temporary hearing that's designed only for me to make a determination of what should be done on a temporary basis. You have the right to testify if you choose to do so. You're not required to. I'm not asking you to. I'm simply saying this is your opportunity to tell me your side of things if you do. If you testify, then Ms. Duke will be able to cross-examine you, after you've finished giving me your original testimony. So it's really up to you. Do you want to testify and give your version of any of these events? All right, come on up. Ms. Williams, this is your opportunity to tell me anything that you feel like is important for me to know about the matters I have to decide today. And those are the temporary parenting plan for you and your child and Mr. Williams. And then secondly is the division of debt, where you're being asked to assume responsibility for certain debts. So if you want to tell me whatever you want to tell me, I'll be glad to hear it.
A lot of the stuff they did say is true. Obviously, I did have one full-on affair. I never did anything with Clint except hang out with him and do stuff, and I am dating someone now. But my ability to be able to parent is not affected by what I did with him. I have full custody of my 9-year-old child that I've taken care of with his dad for almost 10 years now. We have an amazing relationship. We come to agreements with each other. That's what I want to happen with him, hopefully in the future. And I know everything is just very hectic right now because of everything that happened and how he found out. I should have been the one to tell him. But me doing that doesn't affect my ability to be able to parent Rowan. And for he's saying that he wants what's best for his kid isn't, to me, seeing me every other weekend. That's not what's going to be best for him or either one of us. I know what kind of mom I am, and everybody I'm around knows that. Along with the vehicle, it's caught up to date. I don't have my phone to be able to screenshot that and show him. But I will take over my phone bill. I actually asked him how much it was to pay off the phone so I could put it in my name. And one thing he forgot to say was my car insurance, which I need to put in my name. He forgot that. But I don't think that me cheating on him affects my ability to be able to parent, because when I was doing it, Rowan was at daycare and my son was in school. So I don't think that I was going out and doing other things when I shouldn't have. Or when I saw Clint, he was with him on his day. So I don't, to me, that isn't my ability to be able to take my kid away from me.
Anything else you want to say?
No, sir.
Ms. Duke, do you want to cross-examine?
You've spent multiple nights away from the home, is that correct?
Yes, ma'am.
Okay.
Yes, ma'am.
And Mr. Williams has taken care of the house note and would like exclusive possession of the home. You understand that, right?
I do understand that.
Okay, and do you have a problem with that?
I do have a problem with it because I'm the one that pays the water, the electric, the gas.
Do you want to continue to pay those things?
When
When was the last time you paid them? Let me ask that first.
last time I paid them, I just paid the electric bill yesterday,
How much was that?
$308. The next one's due on the 22nd. It's $180 something.
So it was behind?
Maybe a few days, 8 days, maybe.
And you've repeatedly lied to him about who you're talking to and why you're talking to them, is that correct?
About certain things, I would say, yeah, I haven't told him the full truth.
And so how do you expect this court to believe anything that you're saying today?
Because I have full confidence in myself as a parent, and I know I can parent. I may not be a good wife,
Okay.
but I'm a really good mom.
Okay, but does that explain you going to all of Cody Beatty's children's ball games and not Neelan's ball games?
I missed 2 of Neelan's ball games. One I was in Gatlinburg, one I was out for work, so I don't know how you wanted me to not go to that.
And, I'm not answering questions here, you are, so.
Okay, yeah, I'm just confused how Neelan has anything to do with him when he's not the parent. I'm parenting with his
You
dad.
just need to listen to the questions that you're asked and answer those questions.
And you understand that he pretty much has stepped in the gap for you. He has done the parenting of Neelan, right?
I don't think so.
Well, he doesn't administer baths and make sure that Neelan eats?
A noticeable shift happens once the judge steps in to limit the questioning. That move signals courtroom discipline, not favoritism. Family courts allow relevant evidence, but they also refuse to let emotional disputes consume the hearing.
Neelan gives himself showers, so no. And if he cooked dinner, then I'm sure Neelan did eat.
Okay, and he had a very good relationship with Neelan before this complaint for divorce was filed, didn't he?
Oh, 100%.
Okay, and you ruined that by saying something to him about him filing the complaint for divorce, didn't you? Let me finish asking the question, didn't you?
No.
Okay, so you didn't tell him in front of Mr. Williams that Mr. Williams had filed for divorce and was going to break up this family?
I did not. Nealon actually doesn't even know we're going through a divorce. Nealon knew we split up, and we had that argument in front of each other. Me and his dad had a conversation and decided it was in Nealon's best interest right now not to be around him. And he has physically told us he doesn't want to be around him. He won't even come to our house right now.
Okay. And that's because, are you looking at him for some reason?
I'm just
When
looking at
I'm
him
the one
because-
asking you questions?
I'm just looking at him because that's what's happening.
Okay.
Let's confine our theatrics to asking questions and letting her answer the question.
Sure. You did not care for Nealon like Mr. Williams did you?
That is not accurate.
Mr. Williams pick him up?
Okay, from school?
Uh-huh.
Sometimes, not a lot. My mom did.
And Mr. Williams, well, your mom's moved over an hour away, correct?
Just moved,
Okay.
maybe a month ago.
Mr. Williams assists with making dinners for Nealon, correct?
Occasionally,
Okay.
when we did cook.
And Mr. Williams coached the child. And you want to tell this court that this child on his own had some epiphany that Mr. Williams is a bad guy.
I wouldn't say he did it on his own. He saw us get into an argument.
That's all, Judge.
All right, thank you. You may step down. All right, this matter is here on a temporary custody hearing or adoption of a temporary parenting plan and associated motion. I'm going to rule on the adoption of a parenting plan. Number one, I'm required by law to look at the statute for the factors that are set forth in TCA 366106 in order to determine a parenting plan and who should be the primary residential parent. Those factors are as follows: the strength, nature, and stability of the child's relationship with each parent, including whether one parent has performed the majority of parenting responsibilities relating to the daily needs of the child. The court finds that Mr. Williams has been the parent who has performed the majority of parenting responsibilities during the daily needs of the child based on the credible testimony that's been offered in this court. Both parents may have a good relationship with the child, but Mr. Williams has demonstrated more stability in his life. Each parent or caregiver's past or potential for future performance of parenting responsibilities, including the willingness and ability of each of the parents to facilitate and encourage a close and continuing parent-child relationship between the child and both of the child's parents, consistent with the best interests of the child. And this court is of the opinion that Mr. Williams has also been the parent who has demonstrated the best potential for future performance of parenting responsibilities. His stability, he's living in the home. It's been shown to this court's satisfaction that he was a good stepfather to this Nealon, and that he has encouraged a good relationship between Nealon and his father, as well as to encourage the relationship between his child and the mother. But I also find that the evidence indicates that while Mrs. Williams may deny it, that the facts before the court and the evidence before the court indicates that she has not been above using the relationship between Nealon and Mr. Williams as a weapon against Mr. Williams. In any event, it's an unfortunate situation, but the court does find that that factor favors Mr. Williams. Don't have any evidence to show that either of them has refused to attend the parent education seminar. They'll both have to do that. I do find that the disposition of each parent to provide the child with food, clothing, medical care, education, and other necessities, that is, in my opinion, again, Mr. Williams has been the primary caregiver for the child, and for that reason, I think that factor is in his favor. The degree to which each parent has been the primary caregiver, and that's, again, the parent who has taken the greater responsibility for performing the parental responsibilities, again, I find that has been Mr. Williams. The love, affection, and emotional ties existing between each parent and the child, I think they both love the child, and I think that the evidence is, at least before me, that the child has a very close bond with his father, and for that reason, I find that factor favors the father as well. Emotional needs and developmental level of the child is very young, so therefore it's not really any evidence about the emotional needs of the child. the moral, physical, mental, and emotional fitness of each parent as it relates to the ability to parent the child. I understand what Ms. Williams is saying about the fact that she doesn't feel like it affects the fact that she engaged in extramarital affairs, had other relationships, that it doesn't affect.
The mother's testimony reveals a clear strategic choice. Rather than denying personal mistakes, she separates her conduct as a spouse from her role as a parent. That argument is legally significant because custody law focuses on the child's welfare instead of assigning moral blame between adults.
Her ability to parent the child because the child was never around and taken into that situation. But nonetheless, that is a factor that the court has to consider. And clearly, I have no evidence to indicate that Mr. Williams has got any issues. But Ms. Williams engaging in 3 different relationships, whether they were full-blown, as she said, sexual affair, or whether they were just an immoral, an emotional affair, or teetering on the edge of a full-blown affair, it still clearly demonstrates that she has some issues, maybe in her marriage, maybe in her person, that affect, in my opinion, her ability to parent the child. And for that reason, I find that factor to be in the father's favor. The child's interaction and interrelationships with other siblings, other relatives. I think that the child has obviously grandparents that love him very much and want to be involved in his life, and the fact that Mrs. Williams has now attempted to sever that relationship and interfere with their ability to be involved in this child's life, again, speaks to her parenting as well as her emotional level and this maturity level, in my opinion. And the child does have other siblings in the mother's home as well that need to have some interaction with him. The love, affection, let's see. Number 9, the child's interaction and interrelationships with the siblings. I find that to be an equal situation simply because of the fact that both of them, she has another child that's a half sibling or a half brother to this child. And I think that as well as the other parents, grandparents on the father's side, that those two kind of balance each other out. The importance of continuity in the child's life, number 10, in the length of time the child has lived in a stable, satisfactory environment. The court finds that Mr. Williams has provided a stable environment, that he has, in my opinion, given this child a great deal more stability. In fact, when the child comes to her, when the child's with her and she brings the child back to spend the night at the marital residence with the father, that speaks volumes about the stability in there. So I find that favors the father as well. I do not find any evidence of physical or emotional abuse to this child. Character and behavior of any other person who resides in or frequents the home of the parent and the person's interaction with the child. The only thing I have about that is Mr. Giordano, who is going through a divorce apparently, and clearly the evidence is that the two of them are in a relationship and that they are cohabiting, so to speak, according to the proof. But Mr. Giordano, I never heard from him, so I don't know anything about him other than the fact that he is married and going through a divorce. So we have two people both married, going through a divorce, and they end up in a relationship together, which is not at all unusual in these types of situations. The reasonable preference of a child is not applicable. Each parent's employment schedule, Mr. Williams's employment schedule clearly favors him because he worked with his father and therefore he can make arrangements and has the ability to modify a schedule as might be appropriate. Any other factors deemed by the court just simply finds that Mr. Williams's relationship with his child and his home stability that he can offer the child is much more appropriate, and on a temporary basis at least, the court finds that he should be designated the primary residential parent. The mother shall have I know she says that it's not in the child's best interest for her to have alternate weekends, but neither does this court find that with the lack of stability in her life that an equal residential schedule would be appropriate. And as that, as a result of that, on a temporary basis, she will have alternate weekends from Thursday at 6 p.m. until Sunday at 6 p.m. Any other times that the parties may agree. Now, I say this last part so that Mr. Williams can understand. I understand you may go through this divorce and you may have a lot of strong feelings about her, and her attitude may determine how this goes as well. But this child belongs to the two of you, and both of you should be involved in this child's life, and you should try to facilitate the best relationship you can with both parents. That means you're going to have to set aside the fact that she's been unfaithful to you and that she's moved on with her life. Eventually, you may too. And when that happens, hopefully both of you will recognize that it's really up to the two of you to parent this child. And when you do, if you can set aside the animosity and try to resolve a situation, and if Mrs. Williams can understand that it does her no good.
This section becomes a battle over influence instead of relationships. The questions focus on another child, household responsibilities, and family dynamics, because they attempt to measure who actually provided stability inside the home.
Good to be angry and hostile towards you now that you've been through court, but instead try to have a meaningful relationship with each other so that you can encourage this child to be with the mother. You can give her more time than what I've given. That will not be a violation of this court order. So how this goes from here will be up to the two of you. So the reason I've included language is that the minimum she gets is this alternate weekends on Thursday at 6 to Sunday at 6. And any other times the parties may agree. You love Neelan. Neelan this is his brother. So the more you can allow her to see the child and let Neelan have a part in his life, then the better you are. I'm not saying you have to give her a week on, a week off. I'm just simply saying be flexible and give her an additional time beyond what I've ordered, and I think you'll reap the benefit of it in the long run. But, Ms. Williams, you don't have the right to demand more than what has been ordered. You need to get a lawyer to give you some advice. You need to consult a lawyer at the very least. Regarding these requests regarding the payment of certain expenses, I think what I had written down was that Mr. Williams is given temporary possession exclusively of the marital residence. And she will be allowed, if she has any items there she needs to get, you will coordinate a time when she can recover those items, and there'll be no hostility or anything that will go on during that exchange of those items. She is
Would it be appropriate for there to be a provision that
Yeah, if this child is in or around the pool, it needs to have a flotation device on at all times. There was a case in, I don't know if it was in Nashville, but it was on the news of a child that the parties were all there around the pool and they were having a good time. And there was a 2 or 3 year old child that somebody that fell into the water and they didn't notice it at that time and ended up having to be life flighted to try to resuscitate the child because it can happen that quickly. And so if you're having this child around the pool, it needs to always have a flotation device on. And they make some pretty incredible devices. You can put a vest on them and not worry about it. All right, the mortgage is going to be his responsibility because I've given him the exclusive possession of the marital residence. She will pay for her car, her cell phone, and Apple Watch, whatever that Verizon is. She'll also transfer the insurance on her car to herself. I'm not going to order that she contribute to the daycare because we're going to calculate the child support based upon the proof before me. The evidence that was indicated about her income, I think it was about $3,500 a month is what
It was, and we actually, if she'll provide a pay stub, I don't mind to do it based on.
All right, both sides will exchange. You'll provide with Ms. Duke with a copy of your most recent pay stub so that the child support can be calculated. It will be based on the 90 days for her and $275 for him on a temporary basis, and she will be ordered to pay child support according to whatever that computes to be.
As the decision moves toward the parenting schedule, the judge balances authority with practical advice. Granting the father primary residential status does not become permission to shut the mother out of the child's life. Instead, the court draws a clear boundary between legal rights and personal emotions. Temporary orders are designed to create stability while leaving room for future adjustments if circumstances improve. The judge repeatedly encourages flexibility because rigid hostility usually creates new problems instead of solving old ones. That message carries strategic importance. A parent who refuses reasonable cooperation after receiving a favorable order can later damage their own position. Family courts pay close attention to conduct after the hearing. Winning today's ruling does not guarantee winning the final custody decision if future behavior undermines the child's best interests. The closing minutes quietly reinforce that custody cases extend far beyond visitation schedules. The judge addresses property, financial responsibilities, child support, and even basic safety around swimming pools. Those details may seem routine, but they reveal how family courts think. Protecting a child's daily life matters just as much as resolving legal disputes. Every instruction is designed to reduce future conflict before it begins. The warning to seek legal advice also highlights a common reality for self-represented litigants. Good intentions rarely replace experienced legal guidance when long-term parental rights are involved. By the end of the hearing, the court has created a temporary framework built on structure instead of emotion. It doesn't end the conflict. It establishes expectations, leaving both parents responsible for proving, through future actions, not courtroom arguments, that they deserve greater trust.